Then we see the child starts to grow up. And the research tells us that a child will naturally have one primary bond and point of bonding and attachment during what has been labelled as, you might have heard of this before, it's called the tender age doctrine. Now, the mother's right to breastfeed is sustainable and will be respected by the court, spanning the child's birth up until school age, and by the very mechanisms to which I just referred in relation to the exclusion, expressly or implicitly, actively or passively, of the man from the child's life. Breastfeeding is another way, rightly or wrongly, of ensuring what results in the exclusivity of parenting, namely the mother's parenting. Personally, I think we all might be forgiven for finding the situation rather troubling, especially in light of sociological and behavioural studies that suggest that if a man has not established a meaningful relationship with a child by the time that particular child turns 6 or 7 years of age, it is extremely difficult, if not impossible, to do so thereafter. The child becomes so engaged after that age with developing social networks and interdependency relationships, primarily at school, as you would appreciate, that the father is placed in a pool of people vying for the child's attention, closeness, and longing. The mother, on the other hand, does not have to worry in that regard, since the child has already developed that bond with her from birth as the child's primary carer. Now, the tender age doctrine that I mentioned earlier has existed for many years. It's nothing new. The court is often faced with the situation where the child has been with the mother as the primary carer for the first few years of the child's life, which then begs the obvious question: do we really need to rock the proverbial boat? The child is doing fine, and it is, of course, the child's best interest that is the paramount consideration for the court. The notion of increased incremental time between man and child from around the time the child starts school may seem well and good, but by that time, according to the tender age doctrine, it is often too late for the man to make the sort of significant gains he would like to make in bringing up his relationship with the child to the same level of significance of that shared between mother and child. Then, after the child has reached the age of majority, has just turned 18, the man believes his child support liability has ended. Well, think again. I recall a couple of years ago, I was in my car listening to the radio when a new song started playing by a very popular R&B/hip-hop/rap artist. The song, by the way, was most tactfully titled Gold Digger. Yes. And the one verse that rang most loudly in my ears went along the lines of, and I quote, 18 years, she got one of your kids, got you for 18 years, end quote. Well, notwithstanding the factual inaccuracies of the claims made by the singer, and quite possibly his crimes against good grammar and spelling, I understand the song went on to become a #1 hit worldwide. You see, many men have a hard time reconciling their continued liability towards over 18's maintenance, pursuant to Section 66L of the Family Law Act, which requires the liable parent, much more often the man rather than the woman, to pay towards the adult child's education or mental or physical disability. Further, it is commonly and correctly understood in our society that simply because a man does not spend time with his children, it does not exonerate him from paying child support. In fact, the less number of nights the children spend with their father, the more in child support he has to pay. The Child Support Agency publishes an annual report of their facts and figures. Now, I would ask you at this stage a bit of a curly question in regards to, would anyone care to take a guess at the percentage of male payer parents compared to female payer parents 10 years ago, back in 1998-99? Anyone?
Oh, probably 95% then and 90% now.
Anyone else?
I don't think any women pay, do they?
So, anyone else? Lucky third, anyone? 10 to 1? Well, the answer is approximately 91% of payer parents were male and 9% were female. Would anyone care to take a guess at the percentages for 2006-07?
87 to 13.
The answer is approximately 88% of payer parents were male. I think you've looked that up before. and 12% were roughly female. So it seems male pay appearance are slowly but surely making inroads in levelling the playing field. However, at that rate, by my calculations, if current trends continue, we will eventually see 50% of male and 50% of female pay appearance by the year 2102. Yes.
Does it take into account private arrangements?
I believe it does. They're the statistics on the CSA website. But in between the conception of a child and that child becoming an adult, there arises the additional issue of relocation of the child as well. In a recent study conducted by Professor Patrick Parkinson, widely known in amongst family law circles as being one of the most prolific and respected researchers and commentators in this area, it was found that the court had allowed the relocation of children in 53% of all such cases since July 2006, when the shared parental responsibility reforms had taken effect. Now, the research suggests that men will often and eventually sacrifice their careers post-separation from their partners in order to follow their children's relocation. The study also suggests that women have a tendency to become more mobile, if I can call it that, post-separation, while many men simply give in to proposals of relocation because of the great costs involved in conducting the great courtroom battle in that regard. It is nothing short of mind-boggling that the study reveals that from that small survey sample of 80 participants, it cost the average participant approximately $66,000 to have the matter judicially determined. And there was one lucky participant who recorded an expected estimate of, wait for it, $450,000 to $500,000. If that was not shocking enough, it is astonishing to realise that after a relocation matter is determined, where the mother is allowed to relocate with the children, Professor Parkinson's report suggests that compliance by the mother as to contact arrangements between the father and children remains a significant problem in the aftermath of relocation disputes. In so many cases, men become increasingly disinterested and even estranged from their children due to compliance issues that arise because of distance and conflict with the mother. I personally consider that a very sad situation indeed. If I may turn to property matters, very briefly, the family court primarily bases its decision on two main considerations, one being the contributions of the parties during the relationship and indeed the marriage, and also the future needs of the parties. Now, in the event of the equal contributions having been made by the parties over the course of a marriage, as family lawyers, we more often than not, and I speak for, I believe, the great majority of family lawyers, find that there is an adjustment of property in property settlement made in favour of the wife due to such things as lower earning capacity compared to the husband, and of course, as you might have guessed by now, the fact that the wife has the care and control of a child of the marriage. When all is said and done, ladies and gentlemen, it's very easy for us to sit here and criticise family law, perhaps justifiably, but there is little doubt that recent changes in the law, primarily the Family Law Amendment Shared Parental Responsibility Act of 2006, by saying that quickly 5 times, has at least set men on what I consider to be the road not necessarily leading to complete equality per se, but a type of quasi-equality of recognition. I believe it is important for us to remember a number of things in regards to our judgments and perceptions. Firstly, the new laws haven't really been around for that long. Statistics haven't really been given the opportunity of catching up to the reality and implementation of the shared care presumption in parenting matters. Secondly, I believe it may very well take a generational change of the bench, and indeed society as a whole for that matter, for the full effect of legislative change to take full effect. And thirdly, domestic violence seems like it will always be a determinative factor in family law cases.